All right. Good morning, everyone. Good afternoon, everyone. This is how it's going to go. Today is Thursday, July 7th. We are convening a tax review board session. My name is Melissa Andre. I'm the executive director. And I have to note that please be aware, sorry, Kristen dropped out. Please be aware that this is a public hearing and it is being recorded. Because the meeting is public, participants and viewers have no expectation of privacy. By continuing to be in this meeting, you are consenting to being recorded. At this time, I'd like to give the control to our board chair, Nancy Cameradiner. Nancy.
Good afternoon, everyone. The tax review board hearing for July 7th, 2022 will come to order. We're going to go in kind of a mixed up order here. We're not taking them directly 1 through 7. We're going to start, however, with number 1, which is John Parker, last 4 digits of the docket 6894. The property address is 3005 North 22nd Street. I understand in this case that there has been a request for continuance for the BRT hearing. There's been a request for a 180-day continuance. Who has this matter for the city, and am I correctly stating that request?
Stephen Wakefield for the city of Philadelphia. I'll have all of them, by the way. They're all city cases today.
Okay.
Yeah, the city has no objection. They are waiting. They may be exempted, which would render this whole thing moot.
Okay, and 180 days is an appropriate time period to resolve any issues as far as you know?
I think so.
Okay, then let me turn to the board and see if you have any questions about this, or if you're willing to take a vote on agreeing to this 180-day continuance. If you could chime in from the board, please.
This is Paula Weiss. I would have no problem agreeing to a continuance under those circumstances.
Ryan Boyer, I concur.
George Matthews, I concur.
Dominic Ward, I concur.
And Nancy Cameradiner, I agree as well. So this matter has been continued for 180 days. I would request that if you reach a final settlement between the city and the petitioner and everything is resolved, that you remind the petitioner that they should notify this board to withdraw the hearing notification so that we don't reserve time for something that isn't going to happen.
Okay.
Okay, thank you. I'm going to jump down to item number 6. This is for Parktown Place Associates, last 4 digits of the docket 9473, property address of 2201 Parktown Place. And again, we have some information that needs.
Nancy?
I'm sorry.
Can you repeat yourself? You froze.
I'm sorry. I repeat myself.
Start again. You froze.
Oh, okay. To identify the number as well.
Nancy, just start again. There was a moment you froze. Nobody heard anything you said.
Okay. Now I understand. Okay, so I'm announcing item number 6 for Parktown Place Associates, last 4 digits of the docket 9473. Did that come through? Okay.
Yes.
Okay, before I go on, the property address is 2201 Parktown Place. It's our understanding that there has been a settlement reached. If the city could tell us what that is, because we understand we need to confirm some of this information at this hearing.
Yes, so Mr. Schneider and the city, we jointly sent in a letter suggesting that the board should issue an order directing payment of approximately $1.7 million, which is basically the negative balance on the account. If you give me a second here, I'll try to find the actual number here. So it should be $1,717,335.27 should be the amount of the refund.
Okay. Let me turn to the board. Do you have any questions of the city regarding this settlement that has been reached? It's my understanding we need to ratify the settlement and set up a couple of stipulations with this.
I guess I would just chime in, Mr. Schneider, you're here representing petitioner. Does this meet with your understanding as well, that you've reached this agreement with the city?
Yeah, that's correct. This is a property that has an abatement spanning back a few years that has been implemented, which is and has had a couple of assessment appeals further reducing the assessment. So that's the reason for the credits and the refund on the account, and the amount that was stated by the city is the correct amount.
Okay, essentially, you're.
Thank you for confirming that.
Essentially, you're asking the board to ratify this settlement figure and grant the refund. Is that where we are?
Yes.
And I understand that part of what we are to indicate is that the city is to refund this amount within 60 days of the mailing date of this decision. So that is another stipulation that should be a part of this agreement. So
Yes.
Basically, we're looking at the board granting the settlement that was reached by the city. And this amount is $1,717,335.27. And that this is to be within 60 days of the mailing date of the decision. How does the board vote?
Dominic Ward concurs.
Paula Weiss concurs.
Ryan Boyer concurs.
George Matthews concurs.
And Nancy Kammerdiner concurs. So this matter has been agreed upon, and the actions should be taken as designated. Okay, anything else on this before we move on to the next item?
No, Madam Chairperson, I believe that concludes my business. May I be excused?
Thank you for joining us and verifying the particulars from the petitioner's end.
Thank you.
Okay.
Thanks, Steve.
Yeah.
We're going to turn now to item number 5 on the agenda. Robert Sachs Jr., last 4 digits of the docket 4318. The property address is 3949 Stevenson Street. We're going in the order in which the people who are in the office have arrived, in case you're wondering why the skipping around on these additional items.
Just keep your voice up, okay?
Yes.
Nancy, he's in the room.
Okay, thank you very much. Good afternoon.
Good
Please
afternoon.
identify yourself for the record.
Robert Sachs Jr.
Do you swear or affirm to tell the truth with everything that comes before the board?
Yes, ma'am.
Okay, thank you. When we go forward on this, if you could perhaps be a little closer to the computer and speak up, the mic is at the computer. And so
Yeah.
we will hear you better if you are distinct in what you're saying and are close to the microphone.
Yes, ma'am.
Who has this matter for the city?
Stephen Wakefield for the city of Philadelphia.
Do you have
emailed
any
you, sir.
opening comments before we actually turn to the petitioner?
I think we should have Kristen read the numbers and everything into the record.
Okay, who do
We have Kristen Schultz.
Okay.
Yeah, Kristen Schultz.
Please identify yourself for the record.
My name is Kristen Schultz. I'm a revenue examiner with the Department of Revenue.
Do you swear or affirm to tell the truth with everything that comes before the board?
Yes, I do.
Okay, fine, thank you. If you would read the numbers into the record then, please.
Sure. The petition is for the years 2014 up to and including 2021. The tax principal is $12,914.04. Interest $3,155.62. Penalty $878.04. Liens $717.35. Legal fees $1,059.90 for a total of $18,724.95.
Okay, thank you. Do you have any other opening comments from the city?
No other opening comments.
Okay, fine, thank you. Then let's turn to the petitioner. Please tell us why you're here and what it is you're looking for from this board.
I'm here to satisfy this matter in full today. Please, for the principal balance, no payments needed. I will pay it in full today.
But you would pay it if it were only the principal. Is that what you're saying?
Yes, ma'am.
Well,
That's
Mr.
all I
Sykes,
have.
can you explain to us how this delinquency came about and under what circumstances you're asking us to abate the interest in the penalty?
This past few years, I was grieving from deaths and a marriage divorce from my family, death of my dad, and the COVID, whatever happened, and I'm here to rectify it today. And I apologize wholeheartedly that it even happened.
Your petition indicates that the deed is not in your name yet, but this was back in November of 21. Do you have the deed in your name at this point in time?
If I pay you today, my next step is to transfer the deed into my name and my brother's name. That's the next step in what I have to do.
I'm sorry, I have to interject. The city, do you have any issues with this person?
Yeah, so
buying the property?
he would need to have raised an estate to have standing. So have you opened the estate, sir?
What exactly do you mean?
It's crazy because in Philly, like nobody ever raises an estate, but in the whole rest of the state, when somebody dies, you go down to the Register of Wills, or the Orphans Court rather, and you do what's called opening an estate. So you say, I am the personal representative of this dead person, because all of their property and everything isn't your property.
Last will and testament of my father.
Right. So you would have to file that with the court and say, I'm the executor. So in that will, it probably says that you're the executor, or your brother's the executor, somebody's the executor.
Yeah, me.
So if it's you take all that down to the court and you open an estate. The estate legally stands in the place of the dead person until such time as all the debts of the estate are paid and all of the property is distributed. You are not the owner of the property, right? So right now the estate has to own the property. So basically what I would suggest is that we continue this for 90 days so that he can go open the estate. Sir, legally they can't give you the relief you want because you don't have any standing. If you open the estate and you come back, then you'll be the executor and you'll stand in the place of the dead person. This is how the law works. So all you have to do,
I never
all
heard
you have
such
to
a
do is
thing.
go.
Can I ask a question? Have you spoken to this petitioner before today's hearing?
No.
I never heard this.
We don't have phone numbers or anything like that. There's 575,000 parcels.
There's a phone number on the face of his petition as well as an email. I just
Yes.
feel like this is what a conversation could have happened before we came in here today, because now this gentleman's been sitting here since he filed in 2021. No one has reached out to him and he clearly wants to pay the principal. So, I mean.
Well, he would also have to pay the other. So, I mean, he can't even get the relief that he's seeking because you don't have the statutory authority to waive anything besides interest and penalties. So he's actually asking for
Oh,
more
but that's
than this.
significant.
But
anyway.
yeah, I mean, but at the end of the day, again, this was a conversation before we got here today. This is his day in court, and now you're basically telling him that he's not going to be able to get his day in court, even though he's coming here with $12,000 to pay.
13,000.
Okay.
So it's really not that difficult, Mr. Sachs, but you do need to go to the Register of Wills office, which is in City Hall. They'll walk you through it. They'll give you the documentation.
I've
And
never heard this. I've never heard this in all these years I've had ownership of this house, or
when did your father pass away?
in 2016.
2000. Well, but he is still the owner of the property. You're not the owner of the property, is what Mr. Wakefield is explaining.
I have last will and testament though.
I understand, but that needs to be
Executor.
filed with the Register of Wills, who will then give you certificates authorizing you to act on behalf of the estate.
I'll get down on my knees and beg you. Time is of the essence. I need to get this paid off today. Today.
Now, why is that?
Because it's about time, isn't it?
Well, yeah.
But
I was looking for it.
unfortunately, our hands are tied at this end.
Can we go
because
to the back?
They're
Can we
not
go to the
tied.
back, please?
The city will take the money, Mr. Wakefield.
Yeah. Can we
Yeah,
go to
well,
that?
Please, that
Can we
will
go to the back?
interest and penalty from continuing to grow.
Can we chat, please?
Yes, hold on, everybody, just hold
Thank
on.
you.
Sir, if you just stay right there, okay?
Ryan is just smiling away.
Sir, if you were to come down to the municipal services building and pay the principal off before there's any sort of decision or before you take care of all this, number one, it would stop the interest and penalty from continuing to accrue. And then when they got, so you'd have to pay the principal and the other, right? So column 1, column 4. If you say, I just want to pay these 2 columns, don't make any payment towards the interest and principal, they can give you that amount, okay? You can pay that off. Then when you get all this taken care of, what will happen is when they issue the decision, you just bring it down to the city and say, I've already made the appropriate payments, and they'll waive whatever interest and penalty they waive, right? So if they waive 100% of it, you'll just show it to us. We'll take off the interest and penalty. Everything will be taken care of. Let's say they waive half of it. You can pay the rest at that time, whatever, right? But if you were to go, sort of what they were trying to say before is if you were to go down, we would take your money and you would already be in place, right? So when you got all this like squared away, when you became the executor of the estate, all that kind of stuff, then everything would already be in place. Your waiver could automatically go in, right? So if you want to go pay today, I encourage you to pay today. And I'll even note for the board that I don't actually oppose the relief, right? There's just like a legal nicety here. So, you know, if you're going to pay, great. That's what we want. So I'll even let them know, look, we don't oppose relief, but, they just have to say, look, contingent on you showing that you're the executor or whatever, but you can go pay today. That's fine.
And where do I pay at?
So you know where the municipal services building is?
Not off the top of my head, no.
Okay, you're like 2 blocks away. Okay, so it's at Broad and JFK across from City Hall, right? You're gonna go in, you're gonna go down to the concourse.
Right, okay.
And you just say, look, I'm here to pay, and this is very important, the principal.
Yep.
And the other.
What's the other?
So that's the legal and lien fees. Those are not waivable. So the interest is waivable, the penalty is waivable. The legal and lien fees are not waivable. So you got to pay the principal.
I only have $13,000.
Well, it's not going to be much more than that. What I would pay today, right? Because this will stop the interest from going. And then when you get a decision from them, you can come make an arrangement on the other $1,700. You don't have to pay it off. You just have to be in a payment arrangement for it. All right. So if you were to pay, but it's just by law, sir, we can't waive the legal and lien fees. So that's why I would suggest.
I want this to be over with.
Right. But you got to pay $14,700. If you would need some time to get $14,700, then you should say, look, let me come back in 90 days. I'll be the executor or whatever.
Oh, you don't want to waive it because it's your fee.
No, we can't waive it. We can't waive it. Like, it's a municipal claim. So under the municipal claims and under the Municipal Claims and Tax Liens Act, we can only waive it if the value of your property, if it was sold at auction, would be less than the total liability. Now, the city has a statute that says that you can waive the interest and the penalty, right? So interest and penalty is waivable, but anything that's not interest or penalty has to be collected unless the value of the property is less than your total tax balance.
Okay.
And the other thing is it's not really our fee because, like, I'm not an attorney who works for an outside agency. I am an employee of the city of Philadelphia, and I assure you that they pay me close to nothing. So, they get my 10 years of attorney experience for far less than a market rate. I'll tell you that much. Oh, it looks like they're coming back.
Is that a picture of Ryan Boyer? Because he's still smiling.
He's just a happy guy.
Happy guy.
Everyone back. All right, we're back on. Nancy?
Okay, the board's reached a decision and a couple of my colleagues are going to enumerate that decision on the record.
All right, I'll start, I guess. Mr. Sachs, we did discuss the information you provided today, and it's our determination that at this point in time, you don't have standing for us to go forward. We are going to continue this matter for 90 days for you to get the paperwork in order, either to have the property put in your name or the estate with you as the executor and the documentation to establish that, so that you or whoever.
I don't believe this. I have the money to pay today.
You can pay, but it
Department of Revenue and pay the bill.
It's been since November last year. I'm trying to settle this. November last year. I've been trying to work.
Hold
this
on, hold
out.
on, sir. You're going to listen to what you can do. You're not going to have any outbursts. Listen to what they're going to tell you that you can do right now. Paula?
Thank you very much. You are certainly have the right to walk over to the Department of Revenue and pay the principal amount, which will freeze the interest and penalty until such time as you are back in front of this board for determination as to interest and penalty.
You need to be sure you specify that you're paying principal only. That's an important part of what was just stated. I'm sorry, Paula, I interrupted.
Yeah, thank you. That's an important point, but it is our determination at this point that we do not have jurisdiction to go forward and hear this case.
Yeah.
And what's the reason for that?
Because you don't
You
have
do not have
standing at this
standing.
point. Despite the fact that you may have inherited the property via the will, in order for us to be able to hear this case, you'd have to either be an owner of the property as named on the deed, or you'd have to have a power of attorney. Fortunately, your father's deceased, so you would not be able to obtain a power of attorney. So you then have to be actually the owner of the property. So that's why you are being advised to ultimately change the property over to your name, so that way you have standing in this particular matter.
Yeah, well,
I'm going to interrupt, or he could be the executor of the estate.
I was about to say,
Yes.
That's also not
You're representing the estate.
Yes,
Yes, I am.
Mhm.
Yes, I am.
Do you have paperwork, sir? Do you have the letters of administration?
Yes. Last will and testimony, power of attorney,
That's not-
That's,
executor
that's
of the
not-
will.
That is,
did you go to the Register of Wills? Do you have anything from them that
It names
indicates that
officially
you
as
are the legal representative?
Why am I hearing this for the first time today? I've never heard it before.
this is the first
Nowhere.
time you've had a hearing.
I've never heard this from the attorneys who drove.
Did you ask anyone about this? Inquire of anyone with legal background or understanding of this?
No, I haven't.
Okay, because that's what most people do before they come here, is to try and find out what they have to do to have the legal standing in order to act on behalf of the property. And I'm sorry that that's not been information that came
not
to
in
your
the will.
attention before.
Not in
But
the will, and I had to do
unfortunately,
it.
we do not have the ability to represent you or deal with you from the city's perspective, because you aren't the official representative of the property with something from the Register of Wills or some other entity that really tells us that you are legally entitled to do this.
You will get a letter from the tax review board that this matter has been continued and it will be rescheduled. And at that point, please bring with you either proof of ownership or letters, testament.
I have all that. This is nonsense.
No, you
Have all
do
that.
not have an official letter of ownership or representation. It has to come from a legal entity.
Listen,
The Register
I
of
have
Wills is
to-
the one that
I
is
was-
easiest to obtain.
I was
Mr. Pratt, we're not going to
demanded-
argue with you. That's our
I'm
decision.
not arguing. Can I tell you what? I was demanded to pay it in this order and do it in this order.
You,
Sir, 1 second. This is a real estate property, okay? Whose name is on the real estate property
Right now,
right now?
Robert Sachs Sr.
That's your father, right?
I'm Robert Sachs Jr.
Yes, you're correct. You are correct, George. That is his father. His father's name is what is on the deed. Yes.
Okay. Then how can we accord this, deal today? We cannot do this today. There are some laws in this, city of Philadelphia. We have to follow that. So please understand that. Okay. Thank you.
What did he say?
He's
You
saying
cannot do
that
that today.
we can't do it today.
No,
All right? All right.
you
The
could
next-
go to the Register of Wills. I think you have to have an appointment there, but you could go to the Register of Wills earliest opportunity to
It's already
handle the
registered.
process
That's-
of
that's
getting the
what it's called.
property transferred into your name or being a legal representative of the property. Right now, you have a will that authorizes one piece of that, but it is not officially recognized by the city, which takes the Register of Wills or court. I'm sorry about that, but that is what we face. We can't handle this matter.
It's right here, signed by my dad and me. It's right here,
Sir, it has to be recognized by the.
notarized.
It has,
Sir, there are applications of the law that we do not control. Unfortunately, we want to help you, but there are laws in the Commonwealth of Pennsylvania. And
This will and testament signed.
sir, that's
the
it.
will
Our
is not
decision is final.
adequate for our purposes.
Melissa, I
Yes,
think we need to move
the
on.
next case is gonna be number 4.
Thank you.
Thank you.
Okay, the next matter on our agenda is case number 4 for Kimberly Stallworth, last 4 digits of the docket 4326. The property address is 4900 Saybrook Avenue. And I guess we'll need a minute to get the room changed over.
She already called her case, so just Nancy, she's in the room.
Okay, fine, thank you. Good afternoon. Welcome to the Tax Review Board. I'm Nancy Cameron, the chair of the board. Please identify yourself for the record.
Well, my name is Kelly Lewis. Kimberly Stallworth, she gave me power of attorney and letter of administration for the property.
I'm having a little trouble hearing you. If you could be a little closer to the microphone. And if you would just start out with your name, we need to swear you in before you can go further.
My name is Kelly Lewis.
Do you swear or affirm to tell the truth with everything that comes before the board?
Yes.
Okay, fine. Let's identify who has this matter for the city.
Stephen Wakefield for the city of Philadelphia. And just to make these as easy as is humanly possible, there's a tier 4 UPA on this. So this is no action needed because at the end of the agreement, they're already going to get 100% waiver of the interest and penalty.
I'm sorry, say that again, end of the.
At the end of the payment plan, they'll already receive 100% waiver of the interest and penalties. And every year going forward is also automatically incorporated. So they're already in a payment agreement with the city. They have a tier 4 owner occupied payment agreement. The terms of that agreement already waive 100% of the interest and 100% of the penalty on completion of the agreement.
Okay, so Ms. Lewis, do you understand what Mr. Wakefield is saying? Are you aware of this?
Well,
Did anyone ever explain that to you?
No, but I was aware that there's a tier agreement because I've been paying it and I've been paying the electric in order to keep the agreement in order not to lose the property. Now, the property, no one is there in the property now. The person that was living there was a family member. He's gone because the house was not livable. So instead of.
Ma'am, you should not keep talking because if you keep telling us nobody lives there, I'm gonna have to take your UPA away. So it would just be best if you not snatch defeat from the jaws of victory here.
All right, so let's do this, Mr. Wakefield. Thank you. Why are you here today, Ms. Lewis?
Because I don't want to lose the house and I was trying to see if I can get some of the penalties, the principal and the interest taken off.
Well, principal is not going to be something that we can reduce, number one. Number two, what Mr. Wakefield is saying is that the agreement you already have provides for a full waiver of interest and penalty upon completion of the agreement.
Okay. I wasn't aware of none of this.
Okay.
Yeah, if you come down to the municipal services building and ask them for a payoff on the agreement, they can give that to you. And if you pay off what they tell you to pay off, which will be substantially less than the total amount that you owe. All right, because like the total amount that you owe is
The numbers have not been put on the record, by the way.
it's like 30 grand, but over half of that is interest and penalties. So if you come down and just say how much for a payoff, they can give you the payoff. You just pay it off and the interest and penalty will already be waived.
Okay.
All right.
Do they allow me to make payment arrangements?
Well, you're already in a payment arrangement. All
Okay.
right. So just keep paying on it.
Okay.
But if you pay extra, when you get to your payoff amount, you'll be done. All right.
Can we get
All right,
those numbers on the record?
Sure. Kristen, can you read them into the record, please?
Sure.
Has she been sworn in, the petitioner?
She was sworn in earlier. You can proceed.
Kristen?
Okay. The petition is for the years 1997 up to and including 2021. The tax principal is $11,662.02. The interest is $14,904.62. The penalties $908.56. The liens are $783. Legal fees are $1,785.21 for a total of $30,043.41.
Okay, thank you very much. Do you understand what was already identified for you in terms of what you can do if you want to make arrangements to pay more quickly? You could continue to pay on the rate you've been paying until the principal and a couple of ancillary amounts that are smaller are paid off. Or you could pay more upfront and have that happen more quickly, as Mr. Wakefield has already identified for you.
Okay.
Do you have any questions about that in terms of where you would go if you want to talk to someone and do a more expedited payment arrangement?
Well, it was just mentioned to go to the MSB and ask for payoff agreement.
I'm sorry, I didn't quite hear what
Mr.
you said.
Wakefield, why don't you let Mr. Wakefield email her? I think that, you may be better off just,
Yeah,
That's
ma'am, do you have
it.
do you have an email address?
Yes, I do.
Can you give it to me?
Okay, I'll give you an easy one. It's K Lewis, LEWIS, 5 at ccp.edu.
Okay, I'm gonna email you, and then you can just email me, in response, and then I'll have it.
Okay.
At this point, I would just advise the board to continue this case, just in case the payoff agreement does not occur. And the petitioner wants to come here and get an abatement of IMP if necessary. I just don't think that the board should mark this any other way at this time.
But she's in an UPA agreement.
I understand.
And she's already in an UPA agreement.
Okay, but what about if she can't make that payoff agreement?
Does she have to?
Then she would need to come back
She
here.
can just
She has to an Uber, she just keeps on paying what she's been paying, correct?
Right.
Okay, all right.
She can just keep, yeah, she can keep
She can
paying
just pay her $25 a month or whatever.
until,
Okay.
Is there anything at all that this board can or should be doing at this point in time?
Nope.
Just mark it as no action needed.
I would.
Okay,
Do the board members all agree to mark this as no action needed?
Ryan Boy, I concur.
Paula Weiss, I concur.
Dominique Ward, I concur.
George Matthews, I concur.
And Nancy Camerino, I concur as well. So we're marking this as no action needed, but we urge the petitioner to look into the details on this so that she is aware of just how the process works with the UPA agreement.
Okay.
Thank you very much for coming in. And I think if you follow through on some of this, you can help to guide your own decision in terms of whether you pay off in the pattern that was already developed with the UPA agreement, or if you want to escalate some of the payments.
All right, thank you. Thank you for your
Thank you
time.
very much for coming in.
Thank you.
Thank you so much for your patience and time. All right.
I believe the next item on our agenda is number 2.
That is correct.
This is for Craig Thorpe, last 4 digits, the docket 5922. The property address is 807 North 63rd Street. Please identify yourself for the record.
Good afternoon, panel. David Denenberg on behalf of Craig Thorpe.
Mr. Thorpe also needs to identify himself for the record.
Craig Thorpe?
Do you swear or affirm to tell the truth with everything that comes before the board?
Yes, I do.
Okay, fine. Thank you very much. Who has this matter for the city?
Stephen Wakefield for the city of Philadelphia.
Okay, and if we could have the numbers for the record, please.
Kristen, if you could read the numbers,
Sure.
please.
The petition is for the years 2014 up to and including 2018. The tax principal is $7,084.59. Interest, $3,240.79. Penalty, $754.21. Liens, $356.30. Legal fees, $924.01, for a total of $12,359.90.
Okay, thank you. Do you have any other opening comments from the city's perspective?
Just that if Mr. Dennenberg were to orally petition this board to amend to include all years, the city would not object to that because this was filed so long ago before COVID. So if he wants to have a hearing on all the years today, I don't have any objection, and we can read updated numbers for the record.
Thank you, Mr. Wakefield, but I'm really only here from 14 to 18 because that's all I'm prepared about, and I thank you for the courtesy.
Okay.
Okay. All right. Would you, I don't know whether you're going to make the statement or if Mr. Thorpe is going to tell us why you're here and what it is you're looking for from this board.
Thank you. I will make a very brief opening statement, and then I will call my client as on direct.
Okay, please proceed.
I did upload certain documents around 1:30 today. And I don't know if the city has those documents or not.
No, I did not receive them, but I can look for them. Give me a moment. I mean, and then I can forward them to Mr. Wakefield. Just give me a moment.
Did you send them to the board or did you send them to the law department?
I sent them to the email address that was on the notice.
Real estate at TRB, I mean, real estate, TRB real estate, something like that?
Whatever was on the notice, I'll find my notice.
Okay, I'll find out.
Give us just a moment then.
Thank you. It went to real.est.trb@phila.gov.
Okay, if it went to TRB, that would mean that it came to this office, not to the law department.
Right, because the law department, unfortunately, I don't know that Mr. Wakefield is on this hearing, but the only submission that I know.
He is on this hearing.
Well, I don't know that when I get my notice.
I understand, but I'm just, you know, he is on.
Well, I know, I see him.
Okay, that's true. All our images are on there. Were
Dave,
you able to
I'll,
find it, Melissa?
I don't know. My office is still looking for it.
Okay.
Again, it's by Zoom, so I have extra papers, but nobody's here. But can I make my opening statement then?
Yeah,
Sure.
can you proceed forward with your opening statement?
Thank you. So Mr. Thorpe will testify that on May 31st, 2017, he presented himself in the city of Philadelphia's law department and met with a liaison named Rebecca Fox. Ms. Fox printed an agreement for Mr. Thorpe to pay off the 2014 through 2017 real estate taxes. That was marked as Thorpe #1 in my package. That agreement consisted of a $4,860.94 agreement. And again, these agreements aren't signed, but it's Mr. Wakefield would be familiar with these agreements. there was a down payment made of $1,500. And then after that, 8 additional payments were made by Mr. Thorpe by money orders, all presented to Rebecca Fox at the Law Department. Those money orders would be dated from June 23rd, 2017 until December of 2017. I did not upload the December 2017 money order, but I have a copy of it. The full payment that was made by Mr. Thorpe, we have is $5,460, all made in the year of 2017. When I went to the board alone, they indicated that I should have went to the City of Philadelphia's Law Department and got proof that they received these monies. Appeal was filed. I went to the Law Department in January of 2020, before COVID, and I met with a nice employee, I don't remember her name, and she gave me the printout of all the money that was received by the City of Philadelphia. Those monies were about $5,100, not the monies of $5,460. There's a money order of $300 missing, but for this hearing today, I don't think it's relevant. In 2018, Mr. Thorpe received a real estate tax bill, and attached to the documents that I uploaded as T number 3, he paid the 2018 real estate tax bill of, I think it was 1,700 and change. I have the exhibits in my package. 1,750. And those money orders are also in there, attached to T3 and T4 of the agreement. I think it comes out to $1,820.95 for the 2018 bill. He paid all the money, and the City of Philadelphia still continues to say he owes interest, penalty, and principal for the years 14 through 17, and never credited him the payment for 2018.
So maybe now, I know you haven't done your direct, but do we want to hear from the city as to what payments they've actually recorded or posted?
Yeah, Kristen, can you bring up the payment history on this?
I'm a little rusty. I don't work with tips anymore.
It's T013.
Yeah, I know.
And I have the tips account, Steve, Mr. Wakefield, I have those records here on tips.
How far do you want to go back?
We just need to go to 17.
Only
That's when the
17,
payment
okay.
started.
While she's trying to do that, a quick question. The initial numbers went from 2014 to 2018, but we seem now to be concentrating on 17 and 18. Are 2014, 15, and 16 years that have been satisfied with payments?
Are you
Based on your opening, I think that's what they're saying.
I just want to verify that while we were waiting to get the numbers up.
The reason we're focusing on 17 is not because of the tax year, Nancy, it's because of the payments. That's when he made his payments.
That's correct. All the payments
Just so
were
we're
made.
clear, the 14 through 17, based on what you're opening, the 14 through 17 tax years would have been paid in those initial payments he made in 17, correct?
I gotta tell me who you're asking, Mr. Wakefield or myself?
I'm asking you, you're based on
Okay.
your opening. Mhm.
That's per the agreement that was
Okay.
attached as T1. 486094 would have been the money that was due through 17. Those monies were paid all in 17.
Okay.
The money order receipts were attached to the exhibits, and the city confirms through tips that they got the money. There's one money order that's missing, which is the $300 money order, but I see it on the screen today. I didn't see it in the tips package. But all that adds up to is more than the $4,860.94 that was promised to be paid by Mr. Thorpe.
Okay. Do you see on the screen now the information from the city's system?
Do I see it?
Yes. Can you see it on the screen there?
Yes.
Okay. Can the
Is
city
that-
give us a verbal rundown on what it is we're looking at here?
I
These,
got-
yeah, so these would be all the payments starting at least from January 1st, 2017. So there's a postmark column, which if you look at the first one, would have been, the payment was postmarked July 14th, 2020, and the amount of the payment was $225. So it looks like the ones more towards the bottom of the screen are the payments that he's claiming that were made as part of the agreement. There's payment 850, which was May 22nd, 2017, $650, May 31st, 2017, $600, June 26th of 2017, $600, July 31st of 2017, $600, September 6th of 2017, $600, October 17th of 2017, $600, November 21st, 2017, and $600, December 4th of 2017.
And if you add up all of those payments, they are more than what was promised under the agreement that Mr. Thorpe made with the city liaison, Deborah Fox. And there is a copy of the agreement that was attached to the cover page of my exhibit package.
Thank you. And Mr. Wakefield, have you seen that agreement?
I have not seen the agreement, and also it doesn't make any sense because the taxes are about $3,000 a year in principal. So we would not have taken $4,800 as payment. Kristen, can you look in tips and see if there's a payment agreement that matches those terms in tips?
Yeah, there was. I mean, I don't know if I can shed some light. There was a loop assessment that happened after the agreement was entered. So the agreement was entered in May of 2017. And then there was a loop assessment in October of 2017, removing that loop. So that's why
What is a loop assessment?
the long-term owner occupied program, that there was an audit that was conducted that he wasn't entitled to that program. So it was removed.
If he lives in the property and made an agreement, he would either be entitled to the loop because he's been there since 92, or he'd be entitled to the homestead.
Well, so loop has other requirements beyond living in a property for a long time. So there has to be a certain amount of increase in assessment. There are income limitations. And so there are any number of reasons why you don't qualify for loop. It's not just an automatic, he's lived there for an X amount of time. And the homestead is worth about $400 a year. So yes, he would be eligible for that. And if we look, I mean, he might even, that might even have already been on the account. It does not look like it. He does have a homestead for some years. All right, not for the tax years that are in question, but he did have the homestead starting in 2020 and on, which is when he applied for it. So the reason that he has a balance now is, as Chris had explained, when you sign up for Loop, when we signed up people for Loop in 2014, we were so overwhelmed. We told people, look, we're just going to put you in, but it was right on the application. We're going to put you in, but if we find out later on that you don't belong in, we're going to take you out, and you agree that's okay. It's part of the application. So his
Alright, so
Loop
let's-
is
Go ahead.
based on the revocation of his Loop, his tax amount changed from, like $1,400 a year, which is when he got into this agreement to pay his back taxes, to close to $3,000 a year. And so that's the reason he has a balance.
Paula, did you have a question?
I was going to just say if we could recap. So, Mr. Dennenberg, is it your understanding that this agreement is a loop agreement? Is that what it says? I mean, we don't have it to
In
look
front of
at.
us. And it
Um,
doesn't, look like the city has seen it as well, so.
That's why I uploaded it. Is there somebody who can upload it to the screen and share the?
I just forwarded it to everybody.
Oh, these are, okay, these are the emails that the attachments you just
Yeah.
sent.
And
Okay.
I also just sent it to you. I believe he's talking about the first screen. I can open up my email. It's just gonna take a bit because I'm not.
Got it.
Well, Kristen, can you just bring it up in tips?
All right, go ahead.
That's what it is, Steve, the
Right.
tips agreement.
Kristen, can you bring it up in tips, please? And then we can all just look at it.
Lock-in, I can't say. Is that? Yeah, I think that's it.
Right.
40, yeah.
So on May 31st, 2017, his tax amount was a certain amount based on him being in the Loop program. Subsequent to that date, Kristen, when was he removed from Loop?
October 20th, 2017.
Okay, so 5 months after this agreement is entered into, his total tax amount changed, which would invalidate the agreement. Because the agreement.
Can I make an objection to that? There's nothing in this agreement that would say that.
Well, so
There's
to the
nothing there.
extent that Mr. Dennenberg would like to rely on this contract being ironclad, what I would say, if that is his argument, right, is that, well, that's a contract then for an illegal purpose. Because
Okay.
under the Municipal Claims and Tax Liens Act, the city is not allowed to contract with an individual to accept less than the owed principal on the account. So if he's just going to say, look, it doesn't matter what happened after here, it doesn't matter that the assessment became more, and it doesn't matter that the taxes became more, that would invalidate the contract, because we cannot accept less than the full principal. That's a state law. And so if that's his argument, well, then the initial contract is void. And because the initial contract is void, because it is for an illegal purpose, it's not voidable, it is void.
Well, hold on, let's take a couple steps back. The city representative just testified that he was in the Loop program as of May 31st, 2017, and subsequently was pushed out in October of 2017.
That's what they say, but show me some proof he was pushed out.
So that was going to be
There's
my
a letter.
question. Is there
Chris-
something in the system that shows that a notice was sent out to this taxpayer notifying him that he was no longer in the Loop program? Let's start there. I think we should let's work it one piece by one piece. Is there something in tips that shows that a letter went out letting him know he was no longer in the Loop program? Because ultimately, I'm just going to tell you right now where my mind is at. You guys continue to take these monthly payments from him, even though he was pushed out as of that time frame. So I understand your argument from the city, but I think you have to take a step back and let's just work through the facts that we have in front of us right now before we want to start citing statutes. So is there something, let's start there. Is there something in the system that shows that he received a letter saying he was pushed out of the Loop program?
So can you bring up whatever notes we have about the termination of Loop, please?
Yeah, I mean, I would say there's no notice in the system. I mean, everything is house paper.
So then how do you know when he was pushed out of the Loop program?
Oh, okay, I'll show you. And I feel like, yeah, and I believe that Mr. Thorpe was actually advised of this also. I mean, because I think I've had first,
Objection,
yeah,
objection. Please show proof. This is a lawyer. Mr. Thorpe has been a lawyer for 45 years.
I
So,
actually do
Christy,
have
can you
email.
please just-
Yeah.
Can you please
Yeah.
just bring up the screen
Yeah.
that shows when he was kicked out?
There you go.
please? Thank you.
10/20,
Tell us what
2017.
we're looking at here.
Mhm.
So if you look at the bottom,
Okay.
so this was the date that there was a change, 10/20, 2017.
And-
Okay,
And how
it
do we
is-
know what that says?
Yeah.
So if we're looking at the 2016 year. So this was the original assessed 2016. And this would have been the amount that was reduced. And the bottom, 5/4/16. So next was 2016 as of 10/20/17. Then that is no longer, the reduction is no longer there.
But how
See if
did
I
the
can-
Are there any
owner of the
notes?
property learn this? Is there anything that you can either show us
Yeah.
or tell us?
Yeah, can we
Yeah,
go
let me just look and say something.
We
that
check
I
the
might do.
correspondence screen to see if there's anything in there that shows that a letter was sent out.
'16, 2017. Well, there wouldn't have been a correspondence from
Okay.
the system because it was all done, by the examiner. Any
But no, every
correspondence.
time,
Wait, I saw something that said correspondence. Is that,
That's about the homestead.
Yeah. It'd just be anything. Let me see.
Here, not here, give it there.
they give it and they take it.
Okay, so can we hear from your witness?
Can we
Sure.
go back? I'm sorry. There was something there from 2017.
Well, this
No.
would be. All right. So this was a note that the examiner put on,
Okay.
which is under something different. So I'm sorry, what is it that you were for 2017 you were looking?
Yeah, right around here. What is this recert notice cancel? What is all of that?
So it looks like there would have been, I guess, a bill for that year. And then whoever may have canceled the bill from going out. I'm gonna assume. I don't know. I don't deal with the billing. Bill sent, let me see.
While you're searching for that, can we hear
Yeah.
from petitioner to find out how much money did you actually pay in then? I heard in the opening from your counsel, but I'd like to hear from the petitioner as to how much money he actually paid the city pursuant to these tax years.
Okay, I can. Mr. Thorpe, you have already been sworn in.
Yes,
State your name, keep your voice up as loud as you can.
yes.
State your name.
Craig Thorpe,
And are you familiar with 807 North 63rd Street?
yes.
How are you familiar with that property?
I've owned the property since 19.
can you speak up a little bit more toward the mic, please?
Yes, I've owned the property since 1992. I believe it was 92.
And have you lived in the property since 1992?
Yes,
Did you fall behind in paying your taxes in 2014,
yes,
15, 16, and 17?
yes,
Did you go to the city of Philadelphia in May of 2017?
yes.
Do you remember when you went down there?
The exact date, no.
Okay, I'm going to show you what
Probably
I
about the
marked as
17th.
T1. What is the date of that agreement?
5/31/17.
Where did you go to make this agreement?
Law Department, 5th floor, municipal service building.
Do you remember the individual who you saw when you went there?
Yes, I met with Miss Deborah Fox.
When you met Ms. Fox, did she go into the system and type up an agreement?
Yes, she did.
And what was the agreement?
The agreement was for 4860.94 with payments over 6 months, I believe.
And did you bring with you today all of the money orders that you paid to the city of Philadelphia from May of 2017 through December of 2017?
Yes,
And are these the money orders that you have?
yes,
And did you make the payment of $1,500 down as was required by the city liaison, Ms. Fox?
yes,
And was that $1,500?
yes,
And was that made in two different money orders?
yes,
$850 and $650?
yes,
And was that document uploaded to the full board today?
yes,
Did you then make a $300 payment on June 23rd, 2017?
yes.
Does that payment show on the city's website, city's tip site?
I think I did see a $300 payment up there. I'm not sure.
Okay, but that didn't show in June of 2017, did it, sir?
No,
Okay. And did you continue to make your $600 payments each month to the city of Philadelphia?
Mr. Denenberg, not only did I make my payment each month, I went to the law department each month and met with Ms. Fox each month.
And when you made those payments, did the city of Philadelphia give you receipts under the tips designated payment?
Yes,
And would they also be listed on the documents I uploaded as T2 to the panel today?
yes,
And they were for all the months of July, August, September, October, and November.
yes,
Did you find today your December 2017 payment of $600?
yes.
And was that made on November 28th, 2017?
I believe it was made, okay, yes,
And is that also listed on the bottom of the this form that you have that unfortunately I did not upload?
yes,
Did you pay all of the money of $4,860.94 to the city of Philadelphia per the agreement you made with Ms. Fox?
yes. Plus there was, actually I paid more than a $48.60.
Did you ever receive a letter from the city of Philadelphia saying, hey, we're revoking your loop?
No, and in fact, I was meeting with Ms. Fox every month. So we were constantly in touch and having dialogue.
And did she ever tell you as a city officer that they're taking away your loop?
No, she said that the agreement should bring me up to date and I could start with a new agreement for 2018, which we were going to make in January.
And in 2018, did you go down and pay your real estate taxes to Ms. Fox?
Yes, but it was Ms. Williams at that time. Ms. Fox was reassigned.
And tell the panel, in July of 2018, did you pay the city's payment of $1,750?
Yes,
And did you upload those money order payments in the documents that I've uploaded today with the city?
yes,
Did you pay your real estate taxes for 2018?
yes,
And is the city of Philadelphia still asking for payments of the full amount of $3,325.79 for 2018?
yes.
Now, there was, I'm sorry.
Okay, thank you. No, you can keep going. I'm just taking notes.
And are you here today to seek full payment for the agreement that you reached with the city of Philadelphia?
Yes, that was the purpose of making the agreement, to bring me current and to keep me current going forward.
That's all the questions I have.
Have some brief cross,
Yes,
if I might. Chairman,
Please proceed.
thank you. Is your email address cltpc@aol.com?
yes,
Okay, and on the morning of Wednesday, April 18th at 11:33 a.m., is it your testimony that you did not receive an email from the city opening, "Good morning, Mr. Thorpe. Per our telephone conversation yesterday, please see the attached of the payments that you've made during the 2017 year." Is it your testimony that you've not received an email from the city with that opening on that day at that time?
Can we see the email?
And what year was that email?
Yeah,
You
what
just
year
said
was this and can we see the
April.
email? This is,
Kristen, can you
And
please
where,
bring up
where is
the email?
this?
where is this email?
Well, this is cross, but I'll bring it up. You know, he's saying that he never got anything. So Kristen, if you could bring up that email, that'd be great.
Yeah.
Can I just ask one favor? The year of the email?
Yes, we asked that. He's gonna show the email.
I know, but if Mr. Wakefield could just say the year so I could write it down.
For Mr. Dennenberg, the email is Wednesday, April 18th, 2018 at 11:33 a.m.
Do we have that we can see it, or is that not something that you
Kristen's
have
gonna
on
bring
the
it up
screen now?
on the
Yeah,
screen.
I gotta find it again.
You forwarded it to me.
Yeah, yeah. No, that's not the one. Let me see. This one.
So you're saying you didn't get this email?
No, I'm not saying I didn't get it. This is the email that I got after I had finished paying off the agreement, and there was a dispute as to why these charges were put back on. So the agreement had happened, I paid in full, and then I got a notice with all of these back payments on there. I inquired about that, and when I inquired about that, this was the response. And this was the first time I got a response saying that my agreement wasn't valid. But during the time, yes, go ahead.
But as of April of 2018, you had noticed that the loop had been revoked and that the additional payments were due.
The email speaks for itself.
Yeah, subsequent to
the agreement.
Yeah, subsequent to the agreement and me paying the agreement off, yes, I received that.
No further questions for the witness.
No redirect.
So for clarification, base city is the principal amount of $7,084 that is due and owing based on the numbers read into the record. Does that represent the $4,860 that was paid in 2017 and subsequent 1750? Have those credits been applied to the account?
Yes, they have been.
Okay, so he owes after those payments the 7084.
Correct. Yes. Yes. They're all accounted for.
And the city's not opposed if he's going to pay the principal and the other that is on there. We're not opposed to him getting some interest and penalties relief. But I wanted to make it very, very clear that, you know, that's the extent. Well, first off, it's the extent of what you have jurisdiction over for real estate. But also, you know, that's the reason that he owes this extra is because he got his loop revoked. And when you apply for loop, that's part of the application. They say, look, if we figure out that you didn't deserve this, we're going to take it away and you agree that you're going to pay. So that's part of the loop application.
Yeah,
Can I ask Mr. Wakefield a question? Why if my client lived in the property, occupied the property, they took away his longtime loop that he was getting for all of those years?
Kristen, do we have any notes about that?
It looks like that there were two notices that were sent requesting documentation that wasn't received.
Do you have them in the system that we could see those?
I actually did find them. So I feel like this was the first one.
And Kristen, if you could just read for the record what the date of that letter is.
Yeah, sorry, I just lost it. October 3rd, 2016.
And what's the gravamen of the letter?
It's just saying your account's been selected for a routine examination of your loop exemption status. They asked for documentation, any of the two, front page of a federal tax return, a gas or electric bill, a driver's license, voter registration, a monthly mortgage billing and to, to an address, an email to send it. And then I feel like.
And then what happened with that afterwards? Was there a follow-up in terms of
There was a second
acceptance or
letter.
rejection?
Yeah, there was a second request, same thing that we didn't receive. So it was December 7th, 2016.
Mr. Thorpe,
And then
do
I
you remember
believe-
getting that letter and then the follow-up request?
I actually do remember getting the letter and responding with the information that they asked for.
I mean, he's a licensed attorney practicing law. It's all a public record. He's been there for almost 30 years. And he went in and gave this information to the city attorney, Deborah Fox,
Right.
and made an agreement.
Whatever they asked before, I gave them.
He hasn't changed. His tax bills go there. His voter registration is there.
Mr. Dennenberg, what kind of building is this?
House,
Just a single family house?
Yeah, well,
he has a small law office there.
So it's a mixed use property.
Yeah, it's a mixed use property on 63rd Street.
It was an office and a home.
Yep.
Do we need a minute for the board to talk about this?
Yeah, can we get a minute, please?
Yeah, I just want to make sure the board sees my exhibits, because without seeing the exhibits, it shows you step by step of what was done, what was paid.
Mr. Dennenberg, I want you
Yes.
to know that I received your exhibits. I forwarded it to everybody here.
Thank
Mr.
you.
Wakefield, did you get the exhibits that I sent?
Yes.
We
So
have
the board has also received them, so everybody has those exhibits.
Could we step to the back, Melissa?
Absolutely. I just wanted to assure Mr. Dennenberg they were sent.
That's all. Thank you so much. Appreciate that. I know it's hard by Zoom.
adjournment.
They got a full desk, we got nothing.
Yeah, they should at least give you a bench, right? They have exclusive control over that. So I don't know the numbers that they put in. That's what the 16 led 7 to the current stuff. That's what made the 16. It really should be 88, 800, 8,800. But I should actually no, 0. Right. Right. So that all that what they put back in. They haven't been there. Watch Carla. Something's left. That's it. Now that you pay me all the money, you owe me. Iceberg slab, that's what it is.
I mean, Kristen, can you stop sharing the screen?
Yeah.
Thank you. It'll just make it easier for everyone to see.
Yeah, sure, no problem.
My board is not back. Hold on a second.
They're sort of important.
Everybody should be coming back. 1, 2, just fine. All right, everyone is back. Nancy, Dominique.
All back. I think, is it Dominique who's going to take the lead for us in identifying our decision at this point? You're on mute.
Definitely was on mute. Thank everyone for your time today. The board has deliberated, and based on the evidence that we actually had presented us today, we have decided to grant the petition. The petition has been granted because ultimately, based on the agreement that is presented to us, there is no disclaimer on there that in the event of a re-audit or reassessment, that the petitioner can then be rebilled for those back years. Ultimately, the contract laws of accord and satisfaction were met based on the agreement that's in front of us for those respective years of 2014 to 2017. He concluded the respective payments pursuant to the agreement. So as a result, those years were satisfied at that time. Subsequently, although he was taken out of the loop program, that's the testimony we heard today from the city, he was also then put back in. So at that point, we made the conclusion that he probably was eligible for the loop program throughout the entire time. So as a result, again, the reassessment would be invalid. So you will receive a decision in the next 30 days. If you want to appeal, advising your appeal rights, you have the ability to do so. We're going to assume at this time that you're not. But if you do not appeal, then this matter has been resolved and no more monies are due and owing by the petitioner.
Just for purposes of the record, I would like to register my objection that you don't have jurisdiction over anything but interest and penalties. And so to the extent that there is any abrogation of any amount besides interest and penalties in the official decision, it is outside the jurisdiction of the board. I apologize. I just have to make, I have to raise all our issues, so that I can show that they were raised on appeal.
So noted.
And may I say one other thing? Is 2018 also a zero balance?
2018 would not have been part of the agreement. So the agreement years,
14 to 17.
Or 14 to
But
7.
my petition was also for 2018, and Mr. Wakefield had indicated that, and my application was from.
Actually, it was not, sir. The petition, which I have in my hand, says 2014 to 2017.
Yes.
Okay.
Mm-hmm.
Some of the numbers read into the record initially included 18, but that was from the city's end, not from the petition that came before the board.
So for the petition, for the decision of the board, we're going to 17.
Thank you.
Ryan Boyer, I concur.
Paula Weiss, I concur.
George Matthews, I concur.
Nancy Cameradiner, I concur.
And I read it into the record, so Dominique Ward, I concur.
We thank you very much for coming in today. You'll get a letter from us that spells out our decision. Both sides have the right to appeal to the Court of Common Pleas within 30 days of the date of that letter. Assuming for the moment that neither side is going to choose to appeal, then at the end of that time period, that decision would be fully in effect.
And the panel has my address, is that correct?
Yes, I believe we do. Melissa, can you verify that we have his address?
Did you get the notice, Mr. Denenberg?
I did. Everything is by email. Will the notice be by email or by letter?
By letter.
By letter.
1315 Walnut Street.
One more time?
1315 Walnut Street.
You got it.
Yeah, that's what we have on our records.
And you know where
Okay.
Mr. Wakefield is, right?
No, sometimes we don't know where to get them.
Thank you for your humor.
Thank you very much for coming in.
Thank you. Will we be excused?
Yes, you may.
Thank
you,
you.
Dave.
We have items 3 and 7 that have not been addressed, and I
No,
believe
no,
Melissa's
Nancy.
checking.
Nancy, case number 7 is present.
Okay, that's what I was just gonna say. You were checking to see if anyone was here. Case number 7 is for Miguel Santana, last 4 digits of the docket 4428. The property address is 828 East Madison Street. Please identify yourself for the record.
Hey, how you doing? My name is Miguel Santana.
Thank you. Do you swear or affirm to tell the truth with everything that comes before the board?
Yes.
Okay, when it comes time for your further testimony, if you would try to be as close to that microphone as you can, that's where the computer is, and speak up so that we can all clearly hear you. Who has this matter for the city?
Stephen Wakefield for the city of Philadelphia.
And do you have numbers for the record?
Kristen, could you please read those numbers into the record?
Sure. The petition is for the years 2018 up to and including 2021. The tax principal is $2,438.70. Interest $460.09.
It's from
Penalty.
2003, 2017. Because I came like 4 months ago for the same years, and they only give me 17 to 21. That's why I came here again, because I have to come to, they have to approve from 2003, 2017, because the lady approved me the interest. She took the interest and the penalty from 2003, 2021, but they only give me from 18 to 21. That's why I'm here again.
Do you mean 2013 to 2021? Excuse me, do you mean 2013 to 2021 or
No, no.
2003 to
Three.
2021? 3, okay. Tres.
I'm just looking for the petition that we received, and it simply says see bill, and the bill went from 13 to 21. The bill that was attached to the petition did not go back any further than 13, and the petition itself just says see bill.
There is a prior line though on that bill.
Oh, I see okay. I see what you're referring to. I was only looking at the dates. There is a statement for prior that compresses a number of other years without stating which years are represented there.
All right, well, I think we have 2 things. We need to, could we swear in Mr. Santana? Number
I
1.
thought I did, but maybe I did not. So let's just be clear on it. I asked him to identify himself for the record, and I may not have said, do you swear or affirm to tell the truth with everything that comes before the board?
Yes, I did.
Okay, thank you. Sorry about that. I thought I had done it. Maybe I
Yes.
did, maybe I didn't, but now we're clear that's.
Thank
been
you.
taken care of.
Thank you. And number 2, Ms. Andre, was there a prior hearing?
Yes, there was. And I think this was the issue. Back on 9/19 of 2018, there was a hearing. It covered the years 2013 to 2017, and it was denied, did not appear. However, previously, Mr. Santana has come into the office, and I'm going to attest to this. He was away. He was incarcerated. Is that correct, Mr. Santana?
Yes, I was in federal prison, yes.
And he has explained to me that he didn't come because he was in federal prison.
With those records you were looking at, is there anything that clearly states years prior to 2018?
Or 2013?
So it does go, excuse me, 2013. I was looking at the 2018 hearing date. My apologies. So they actually go back to 2013. The city was reading numbers in the record that only went from 18 to 21.
Ms. Schultz, can you go back to 23? 03?
Yeah, I can. It's going to take me a while to calculate.
That makes sense. So when the petitioner was here last time, is there any notes in the system from counsel who was here. Mr.
Oh.
Wakefield, are you from, oh, okay.
I think it was a
I-
master
I
hearing.
I have
right?
one other information regarding a hearing. On 4/27 of 2016, years 2005 to 2014 were heard, and again, there was a denied, did not appear. So we have 3 sets of hearings here. The first was in April of 2016, and that covered the years January 2005 to December of 2014. That's the first hearing, and I don't have any information.
At what level was that hearing?
That was at the master.
Okay,
And I don't have any information about where Mr. Santana was during that period of time. I've only spoken to Mr. Santana about the period of 2013 to 2017, when the hearing was scheduled for 9/18, and it was denied, did not appear.
But
I
we
would,
don't have any action that was abating any interest and penalty
That
anywhere.
is correct.
Okay.
Oh, until this last period, which is 18 to 21, or to 20, and there was an abatement on that period of time. There we go.
and that was an abatement by the master,
Correct.
given
and then that
the,
was appealed to the full board.
Yes.
given that he has a decision that was not appealed for the prior years, they should not be included. So all that is on appeal to this board is his application for 2018 to 2020.
20 or 21?
2021 or 2020?
Whatever the petition is,
Okay.
The petition has 21.
then 18 to 21 should be all that's before this board, because he has prior unappealed decisions, and those decisions became final. And there's no jurisdiction to upset those decisions after 30 days. So after the appeal period runs, that's all she wrote under the local agency law.
And that's from 2003 to 2017.
That's
Okay.
correct.
Although we never heard 2003.
That was at the
Well, you-
master's level, correct?
Oh,
Correct.
no, I thought that was 2013. Or
There's no interest or penalty for 2003 or 2004, so there's nothing for the board to hear. So that there's no balance at all for 2004, and for 2003, there's no interest or penalty. There's only legal and lien fees. So there's nothing for the board to hear for those 2 years anyway.
So
let's hear from Mr. Santana. Tell us why you're here, what you're looking for. Tell us about the property.
Okay, I'm here because I came here like for a couple months ago, and I explained that I was incarcerated and I want to keep the property, and that's why I want to explain it to the lady, and that I want the interest and the penalty to take it off for me to go over there to the city and I make an agreement to pay the taxes.
Okay, is this a property you live in?
No.
Okay, what kind of property is this?
It's vacant because I was inside. It was people living in that property, but now it's empty. It's a shelf.
Okay, and have you made any payments recently towards the tax?
I went to the city, and the city told me that they can't do nothing. I have to come back here after, because then they have to give me the approval to go back over there, and they approve they
wouldn't take a payment from you?
No, they're gonna take no agreement or nothing. I have to come here and make it again for them to accept it.
And if we were to make any determination about interest and penalty to lower the bill, are you prepared to begin making payments on the balance?
Uh-huh.
Okay.
I need some help. That's why I'm here, because I wanna put everything back together and get it back in my feet.
Well, counsel for the city, do you have any questions for the petitioner? It sounds like he wants to work on a payment plan.
I have a number of questions for the defendant, actually.
Well, not defendant, petitioner.
Sorry, petitioner. Mr. Santana, you own quite a few properties in the Santana Irrevocable Trust, do you not? Mr. Santana, you own multiple properties, correct?
Yes.
Okay. And on some of those properties, you came into the municipal services building, and despite them being not owner occupied, you got into owner occupied payment agreements on those properties, didn't you?
No, I went over there to get an agreement.
So you got into multiple owner occupied payment agreements on your other Santana Trust properties, didn't you?
No, it was regular agreement for me. The
Regular
lady over there, they did everything for me and the agreements.
Okay. And what years were you in prison?
From 13 to 17, yeah, 17.
Okay, so from 2003 to 2013, you were not in prison,
No,
but you didn't pay your taxes.
it was people living there, like you said, that it was quarter.
But you didn't pay your taxes.
No,
And then from 2018 to 2022, you were out, but you didn't pay your taxes.
I just came out from where there was in halfway house.
Okay.
You cannot, they limit your time outside.
Right on.
I just finished the halfway house and almost done the supervise. You can do a lot of things because when you're in the halfway house, you have to be there and then you have to go a couple hours out and then come back in. It's not like I'm out and I could do everything I want.
Okay.
They're very strict, you know, whenever you move and everything.
Okay. No further questions.
Any questions from board members?
I would like to extend my deepest apologies for you being referred to as a defendant when you are a petitioner in this hearing, though.
Yes, absolutely. I do apologize.
Thank you.
During any of that time period, were you earning income?
Say it again.
Were you earning any income during the period of time that's in question here? I guess that would be the 18 to 21.
Now that's why I'm getting, because I need to fix all this my problem, because with this problem the city doesn't give me no license, and without the license I can take the people out on their properties. That's another thing. That's why I have to fix all this problem and everything for me to go to the city and then get the license and then evict the people that are not paying no rent.
Okay, but you haven't been paying any property taxes on these properties?
Yes, I've been paying a couple of other properties. I've been paying, yes, because
on the property that's before us today?
No, not on this one. No,
Okay, that was my question. Because that's all we're dealing with right now is this particular.
No, because I went to the city, like I said before, I went to the city and the city saying I have to come back here and fix this problem and then go back over there. And then they give me how you say that, an agreement.
Any other questions from board members? If not, are you ready to step aside to consider a decision?
I guess I just want to, we stopped in the middle, but the numbers, can we just have the numbers for 2018 to 2021?
Sure.
We never finished them.
Yeah, no
Okay,
problem.
thank you.
No problem.
I forgot about that.
So the petitions for the years 2018 up to and including 2021, the tax principal is $2,438.70. Interest, $460.09. Penalty, $164.52. Liens, $365.80. Legal fees, $205.74, for a total of $3,634.85.
Thank you.
So what was the penalty figure again?
$164.52.
Thanks.
Okay. coming back to the board. Are there any other questions you want to ask before we step aside?
I
Nobody's
just have
speaking up, so I guess that means we're ready to step aside and discuss the case.
Mr. Wakefield, do you have a closing remark?
Yes,
Oh,
thank you. This is a multi-tax property delinquent who owes 20 years of taxes on multiple properties, tens and tens of thousands of dollars. This is not his home. You know, he could have sold these properties at any point to pay his balances off. You know, so I would suggest that this is not an appropriate use of the board.
Okay. Thank you. I guess we're ready to step aside then?
Yep, everyone can hold tight.
Problem?
Kind of like this Zoom stuff. I can multitask.
Right? I'm going to be so sad when court goes back to being in person.
That's one of the worst when you're sitting there and you know you have so much stuff to do. Like, so at least sitting here, I can like try to get some other things done.
How's life in revenue?
Oh, it's wonderful.
Is it wonderful because you are in typical Kristen fashion taking on a bunch of stuff that's not
Yep,
yours?
that's
because
why
you're
Kristen.
controlling?
That's why Kristen's sitting here today. Yes.
You know, you could have done that in the law department.
I know. I could have.
You can always come back. Your job is still open.
All my good people left.
We actually.
Oh my God! Like all my people left.
We have Tony's gotten a new decent crew together.
Yeah, he introduced me to the one. I forget her name. One of the legal assistants.
Felicia, Jen, Malika.
It might have been Malika, I think.
Jen is Judge Young's daughter.
Okay, yeah.
Right, Judge Young, who left to go to federal court.
Yeah.
But she and Felicia and Malika are like some of the best legal assistants we've had in a long time.
That's awesome. No, that's awesome.
Right. In part
They
because
actually
like,
have that background. They actually have that background.
well, also like the people who were a problem and were like visibly not doing any work, so that people were like, well, if they don't have to do work, I don't have to do work. Those people are gone.
Yeah. That is one good thing kind of about working remotely too. That
Right.
those good people don't get tainted by that bad.
Right. Because they don't see.
They don't see it. Right. Yeah.
Right. They
yeah.
don't see that Ellie is just sitting there doing nothing.
Yeah. I'm in the office every day. I kind of like it because no one's here. I mean, sometimes it's frustrating. Sometimes I would like to sleep in and not have to commute, but I am here every day.
We're in 2 days. The rest of the law department's in 1. I cannot express to you how resentful I am of every minute that I'm in that office. Like, it's just such a colossal waste of my time.
Yeah.
Like, in part because like so like I'm technically on vacation today. I took vacation this week so that I wouldn't have to come into the office. Like I blew 4 vacation days this week and I worked anyway.
I know.
Just so that I wouldn't have to go into the office. That's
Yeah.
how much I hate it.
Yeah. No, I know. That's why I actually emailed Tony because I was going to email you to see who was doing this today. Then I saw you're out of office. And then I was going to email Sam, and then he was out too. So I emailed Tony. I was like, do you know who's doing the things today? Or yeah. So he said Mary Kate.
No, I just like, I didn't have any court this week, so I didn't have any reason to be downtown. And like, when we were 1 day a week, if your day in the office was a federal holiday, you didn't have to come in.
Okay,
and Francis is like, that's over.
Yeah.
If your day is a federal holiday, everyone has to come in Tuesday, and then everybody has to come in another day. And it's such ridiculous virtue signaling, right? Like, it's just like the most like ridiculous, I'm infinitely more productive at home. And then the thing is, like, when you're an attorney, you're never not working, right? It can be like 11:30 at night and you're like,
you're still doing,
you just have a thought, right? Like, your thoughts are your work product.
Yeah.
So if you think about a case, you're working, right? And like, so being at the office like from 9 to 5.
I mean, like some days I do ask to work from home. Like most of the time it's usually meetings, which are just on the computer. So I'm like, I can do that at home. And I feel like, imagine that I feel like I work more hours when I'm home than I'm here.
Well, that's the thing.
Because I'm like, oh, there's a commute time. Like, let me just like here, I'm just like, I just want to finish it, but I have to go home. I got that hour commute. So
right.
Yeah.
And the thing about working from home is you will work until the work is done.
Yep.
Right. Like nobody's at home and being like,
okay, well, back on the record. Sorry.
Yep.
All right. Nancy? Here we are.
Okay. Are we all back?
Yes, Nancy.
Okay, thank you. The board has reached a decision. First off, I want to note that we're only addressing the years 2018 through 2021. And it's our decision to abate 50% of the interest and 100% of the penalty. You'll get a letter from us that spells out our decision. Both sides do have the right to appeal to the Court of Common Pleas after receiving that letter within 30 days of the date of that letter. Assume for the moment that neither side's going to choose to appeal. And at that point, then you should be talking with the law department to enter into appropriate payment arrangements. Any questions?
The law department will not be appealing, Mr. Santana. So if you just go ahead and bring your decision letter in, we can get you taken care of once you get it.
Okay.
All right. Well, thank you very much for coming in, and you'll get your letter within a week to 2 weeks. I'm not sure how long they're taking now. As with most other things, the mail is slow. But once you get your letter, the 30-day period for consideration on either appeal or action will start out. And so you'll have the 30 days from the date of that letter. We thank you for coming in.
Ross Matthews, I concur. We have to concur.
Oh, yes, I'm sorry. We should have put that on the record.
Paula Weiss, I concur.
Dominic Ward, I concur.
Is Ryan still with us or did he have to leave?
Oh, he is no longer here.
And Nancy Cameron, I concur. That concludes our testimony with an action with this item. Do we have anyone here for item 3?
Let me just go check.
Thank you.
Thank you. You can leave at any point, sir.
No, we do not have anybody else.
Okay. Okay, item number 3 is for Dennis Selden, last 4 digits of the docket, 5164. Property address is 1422 North 53rd Street. And we have an attorney listed here, but I think in some conversation earlier, there was an indication that there's been a potential problem with his address.
I'm
So,
actually gonna take that back, Nancy. I just checked his email address, I mean, his physical address. It is the same as what is on our letter. So what I thought
okay,
was-
so we don't have to put an asterisk on that. We can just indicate that this is denied for failure to appear. Any other comments on that before we go to a vote? Whoops, something coming up?
Yep, I apologize, but it's weird. I have something that says it came back from that address, but then I have a note from one of my staff that the email was sent to the attorney. So we sent the attorney an email on 6/2/22 at 12:24 p.m.
Okay, and that's definitely enough time for them to have reacted and indicated that they had a problem attending or to actually attend today.
Correct.
Okay,
And I just don't suggest that we mark this as no further rehearings, only because this address situation is still very confusing to me.
But
How
here's
many
an
letters
attorney.
have we had with Bart Levy to which he just has not been here because of
At
this?
least
because of
3
this
or 4, and I'm confused as to what his address is because I know he moved, but all the documents I have don't indicate that new address, and when I Google it, it's the same address as well. So I'll just try to reach out to Mr. Levy to find out what his proper address is.
But we should be marking this as denied for failure to appear in further hearings?
Yeah, I mean, in particular, because we have a return to sender, which indicates that this is clearly not the correct place.
I would say that if this was the Court of Common Pleas, it would be his obligation. This is not a pro se person. Like Mr. Levy's aware of his obligations to boards and to the court to update his address. If the city moved, we're involved in 1,000 cases. We would change our address in every one of those 1,000 cases.
Yeah. But for our board, are we denying for failure to appear or are we also putting no further hearings?
I would just say failure to appear. I guess maybe not marking no further hearings. Is that what we've done in this prior matters? It's just been failure to appear?
I can't say for 100%.
Case by case.
Yeah, case by case.
Depending
Okay.
on how many.
I agree with that too.
I concur. Denied for failure to appear and just leave it at that.
Okay. And was that your agreement too, Dominique?
Yes.
Okay, and Nancy Cameron, I concur. So this matter has been denied for failure to appear. And that is the last item we have on today's agenda, unless there's something I'm unaware of. I'm not seeing anyone come forward with that. This hearing is adjourned.
Thank
All right, bye, everybody.
Thank you.
Thank you.
Bye.
See you again soon.
Bye.